Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Manisha Patel presenting for us. If you are unfamiliar with the format of this event, first, Manisha is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or in the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. So please be sure not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Manisha to get us started.
Okay, thank you, Marissa. We're going to talk about simple divorce in North Carolina, and I'm just going to start with a few different terms. I might call it absolute divorce, no fault divorce, simple divorce. It's all going to reference the same thing today. Okay. This is some information about legal aid. Legal Aid of North Carolina is a statewide nonprofit that offers free legal services in civil matters for low-income people to ensure equal access to justice and removing those barriers to allow everyone to have the opportunity to have their voices heard in court. These are some of the different areas that legal aid does serve, different practice areas, different places where you may have some questions or legal needs. So I urge you to check out the Legal Aid of North Carolina's website. And I'm sure Marissa has put that in the chat already. If not, she will. So you can have easy access to their website and get some of the information about these different areas that legal aid does assist people with. Again, here's the actual link and the phone line or phone number that you can call or you can apply on their website. So I'll leave this up for just another second so you can click through it. With that, we're going to go into a little more of the substantive. And just moving the little chat box. Okay, here we go. Maybe. There we go. Okay. So today, as Marissa said, legal aid is not your attorney. I'm not your attorney. I'm a volunteer that helps with these listen and learn clinics. And so just be mindful that this is not creating an attorney-client representation relationship, but providing general advice on absolute divorce and filing for absolute divorce in North Carolina. Okay, this is kind of like a timeline of all the different things we'll talk through today, just so you have a roadmap of what we're going to talk about. We're going to talk about first making sure filing for absolute divorce, filing a simple divorce is the right one for you. We're going to talk about what information we need to gather and we need to have collected to prepare the papers. We're going to talk about how we're filling out these papers for court filing. And we're going to talk about the different ways you can file the forms with a court. And then we're going to talk about getting the actual judgment of divorce signed by a judge and having it entered by the clerk to make it official. So this is just a brief roadmap of how we're going to get to the actual judgment of divorce. Okay, first question, is simple divorce right for you? Again, simple divorce, also known as absolute divorce. Okay, first question we're going to ask, have you or your spouse lived in the state of North Carolina for at least 6 months on the date you file for simple divorce? So the fancy magic words are called next proceeding. So the 6 months immediately prior to the date you file this lawsuit for absolute divorce, have one of you lived in the state of North Carolina for that time frame? Hopefully your answer is yes, and we'll move forward to the next question. If not, it's not ready to file in North Carolina because for North Carolina have the fancy word jurisdiction, the power of the court to do anything, one person has to have lived in North Carolina for at least 6 months. Okay, the next question. Let's say the answer to the first question was yes. The next question is, have you and your separated spouse have you been living separate and apart for at least a year and a day prior to that date you are filing? So this is really multi-layered question. I'm going to break it down. So first question is, have you been living separate and apart? What does that mean? That means you have established two separate households from when you were living together as husband and wife. Now, let's say you have already been living separate and apart because of some other reason during the marriage, work, whatever, military, whatever that may be, that you are actually living separate and apart. Well, let's talk about that other piece. Do one or both of you have the intent to no longer live as husband and wife? If the answer to those questions are yes, then let's go to the second part of this multi-layered question of at least a year and a day prior to the date you're filing. So that magic date we call a date of separation has to be at least a year prior to the day you're filing. So I always say a year and a day because that catches those leap years like we had in 2024. But you always want to have that question. Have we been living separate and apart? And do both of us have the intent to no longer live as a married couple for at least a year and a day? You'll see this next little reminder is no try again period. So that means, what if you're doing a trial separation and you are living separate, but you haven't made that decision that you want to no longer be husband and wife? That doesn't count. One other piece is isolated incidents of sexual acts does not restart the clock. So, but if you are having any kind of relations continuously, that stops that year and a day clock. Again, you cannot live in the same house during this year and a day. That living separate and apart means two separate households. Doesn't mean separate bedrooms. It doesn't mean the garage apartment and the master bedroom. That's not separate and apart. We need two separate households. Think of it like two different addresses. Where are you going to lay your head at night? Where do you get mail? Where do you brush your teeth? Where do you make dinner? Those are the kinds of questions that you ask yourself to make sure you meet this living separate and apart requirement. Okay. Is simple divorce right for you? Now, these are going to help you get some thoughts running if this is the right option for you. First, an entry of a judgment of divorce will affect your property rights. Property division in North Carolina, marital property division, is called equitable distribution. I'll call it ED for short. And then we have spousal support, which is post-separation support, and alimony. So a judgment of divorce will affect your finances, your money. So if you have questions about that, a simple divorce may not be the right option for you. If you want to divide assets, if you want to divide debts, you need to spousal support or alimony. I'll call that all the same thing, spousal support. You need to talk to an attorney before you file, because here's the most important thing I'll probably tell you in this phase of our timeline today, our roadmap, is if you have a judgment of divorce entered and you don't have these claims pending before a court, so pending for future determination in any court lawsuit for equitable distribution and alimony, and that judgment of divorce gets entered, signed, and file stamped by a clerk, signed by a judge and file stamped by a clerk, you can never bring those claims again. You've lost the ability to make a legal claim for property division of marital assets and liabilities and alimony. So it's really important, even if you have a question, are you entitled to this? What does this look like? Is it to my benefit? You need to talk to an attorney before you file anything if you have questions about this. And then here's a really important reminder. A simple divorce, an absolute divorce, does not impact anyone's custody rights for children that you have with your spouse. Okay, now that children you share with your spouse piece, that means if you have adopted children together, if one spouse adopted a child of their spouse that they're not biologically related to, children born during the marriage between both parties, or if the two spouses had a child and later got married, all of those custody issues that may arise, absolute divorce will not affect that in any way. You still have custody rights and can address those with a custody action if it's necessary. Same with child support. Child support has nothing to do with absolute divorce, and child support has nothing to do with custody rights. Here, we're simply talking about getting an absolute divorce. And again, I said it at the beginning, we sometimes call it a no-fault divorce. Okay, here we are going into our next step. We're talking about what information will you need to file. So we're talking about we have to file a lawsuit for absolute divorce, and what kind of information will you need to have to fill out the forms? Okay, so I'm going to put two boxes of information. So first, we're going to talk about what information do you, the person who's filling out these forms, need, and about your spouse, your separated spouse. What information do you need from them or about them? So first, for you, your full legal name. I always say, what is on your driver's license? That's going to be the identification that when you get documents notarized, a notary public will look at to verify your identity. So I always say, use your full legal name that's on your driver's license. You'll need your address. Where do you lay your head to go to sleep at night? Where do you brush your teeth? Where do you get mail? Where do you make dinner? That's the address we use for your residence. Your marriage license is not required, but it can be very helpful as you're preparing these documents and as we go through that entire timeline to fill out the judgment of divorce and other paperwork you may need. You also will need all of your children's full legal names and birth dates. And again, if you share these children with your spouse, if it's a child of a prior relationship or a child that wasn't adopted, with you and your spouse, we don't include that. Just the ones where you and your spouse are the legal parents, and bio and legal parents of those children. And then here's some other information. Where are you going to file this action? That might take some thinking about where is the right place. So if you live in, let's say, if you live in Winston-Salem, the location of the clerk of court where you file is going to be in Forsyth County. If you live in High Point, it will be the High Point Courthouse in Guilford County. If you live in Durham, the Durham County Courthouse. So those are different distinctions where you want to look to make it one most convenient for you. And it also goes to, is it where you live in North Carolina or where your spouse? You can file in either one of those. So I would say look for the most convenient for you. Now, your spouse, information that you'll need about your spouse to fill out this paperwork, you'll need their full legal name, date of birth. You'll need their current address, and I'll talk to you why we need their current address. And then here's something else you may not think about, but your spouse's military status. If they're active duty service members, inactive duty service members, or never have served in the armed forces, you'll need to know that information. And we'll talk about why we need that as we go through our roadmap and what forms we're filling out. Okay, other things you'll need. You'll need access to print some of these forms out if you want to file it in person. If you want to file it online, that's an option. But this clinic, this Listen and Learn is going to talk about when you physically take the documents to the courthouse to file. So you'll need to print out the documents. You'll need to find a location and payment for a notary public. I always suggest to people, if you're looking for a notary, go look at the bank where you have a bank account. Most all banks will have a notary and they may not even charge you for it. So I know the UPS store is a common one where you can find a notary, but it might be more convenient and cost effective to go to your bank or credit union, and they can probably do it for free. You might have to make an appointment. So just, it doesn't hurt to call or stop by and ask that question. And then a location of a post office close to the clerk of court, so the courthouse. Usually they're in a downtown area, so there's probably a main branch of a post office nearby, if not one of those blue mailbox receptacles that they have outside. Okay, there are two different ways we can file, and I talked about that earlier. First one is you're going to download all the forms from the website, the guiding file. Then you're going to fill out each form. You're going to file the paper copies with the clerk. Another option, this is the guiding file. This is where you do an online interview survey that gathers all of the information and fills the forms in for you. So you come out with some PDF documents PDF files where you just print these papers out and it's all typed up and nice and clean. That's the other option. It'll be shorter if you gather all the information we had earlier, and that way you have it readily available to just type up. And again, I've looked at this on a mobile device, like on an iPhone. It's a little difficult, so I would say if you're going to use the second option, this North Carolina guiding file, doing it on a computer, a laptop is probably going to be the best option. So even if you need to go to the public library and use a computer there, that might be helpful, or borrow someone's computer. It's probably going to be easier than doing it on your phone. If you don't have that access, I would suggest download all the forms and fill them out. Legal Aid has a wonderful listen and learn packet of all the forms that you can use, and it's on their website that you can go along with this. What we're going to talk about today, this big red circle, cross through circle, is not to say that's not a good option, the form option, but we're going to go through guiding file today. So both of these are perfectly great options. It's what's easily accessible and ready for you. Marissa put the guiding file link on in the chat. So I would suggest, if you can, while you're listening to me talk about this, go through the website, kind of get a feel for what this looks like and what kind of information. Even if you want to do this on your computer while you're listening, you can do that too. What we'll do is we'll go through how to fill out the forms, the interview process, and then when you're done, you verify it's all true. You print the forms when you're done, and you take them to the courthouse to file. Okay. So Marissa also put the link to the divorce packet. So if you want that first option to download the forms and fill them out, you have that option too. So you can download that packet of documents from that link. So North Carolina guiding file. This is a completely free resource that eCourts is what we use as a collective term for different services that our North Carolina Administrative Office of the Courts use. So you can start and stop this process, this interview I mentioned earlier. And then at the end, it auto-populates all the forms. It's all typed up and it just spits out this PDF file where you can download it and save it. And you can print it out, or you can save it and send it to your, email it to yourself or print it out, and then you have them. So it's a great resource, and it really just makes it a little seamless for you if you have the ability to just hop on a computer and spend some time doing this. Okay, so we're going to use this sample case, blue blood versus blue blood, to walk through this process, okay? So what we'll do is, for guiding file, you want to fill the forms out. Again, nccourts.gov/documents/forms. Now, there are certain forms that you'll fill out, and I'm going to give you the form numbers that you can identify and search on this website right here, the nccourts.gov/documents/forms, and the numbers that we'll talk about, you want to make sure you notate those, and then you can search and download the blank forms there. Let's talk about these elusive forms that I've been referencing. First, the complaint. This one is in the Legal Aid Simple Divorce Packet. This is the complaint. This is, it sounds kind of aggressive, but it's just a fancy legal word to say this is the document that you are using to put all of your allegations for why you're asking a judge, to give you a simple divorce. Okay, the civil summons form. So this is the number AOC CV 100. This is another form that you'll need to fill out. This form really is what starts the legal process. For this form, I'll talk about how you fill it out and why it's so important, but it's just to know that you put all the information on there, and this and the complaint together we call process, and those are the documents that start the lawsuit that you have to serve to your other spouse. Moving forward, I'll call them the defendant. And it just gives case information when the court opened the court file. Okay, this is like a screenshot of that nccourts.document or nccourts.gov forms page. That's where you put in the form number. So if you're looking for the PDF fillable form for a civil summons, that's where you put AOC CV 100. Okay, domestic civil action cover sheet. Have a note about this form, but again, this is one to keep in mind, that if you need to pull the blank one, you can. And then this next one, this is the Service Member Civil Relief Act declaration. And this document alludes to, or this references when I mention your spouse, your separated spouse, needing to know their military history. An optional form here is a petition to proceed as an indigent. So if for some reason cannot afford the court filing fees, if you receive TAMP, food stamps, Medicaid, things like that, this might be an option for you to see if the court will waive the requirement to require the court filing fees. And then also optional with this petition is an affidavit of indigency. So this is kind of where you put in all of your income and monthly expenses that will help support your petition to ask the court to waive any court costs for you. Okay, now I'm going to say this over and over, and Marissa's probably going to be tired of hearing me say this all these different times, but make sure you check with your local county about extra forms they require. You want to check the local rules and forms section of your county's page on nccourts.gov. And it's literally called that. You scroll down, once you look at the pretty picture of the courthouse, it'll have the address, the phone number. It might have different links to court personnel or judges or whatever it may be, but there will be a section that says local rules and forms. You want to click through there and make sure if there's anything specific for family court or domestic court that you need to do for absolute divorce. And that's where you probably want to look for the words absolute divorce. Okay, ready, set, file. Let's talk about, you filled out all the forms, what next? Okay, so you're ready to file, and if you have all of these documents, you're ready to go. So first, it's going to be the complaint. When you get those PDFs through Guide and File, you want to print out 3 copies. Don't sign anything yet. I want you to make sure you have everything first. You want to have your domestic civil action cover sheet. Again, this is something to check with your local rules, because with eCourts Live in 87 counties, most don't require them anymore if you file online. So if you're going in person, you probably still want to have this document ready to go. It helps organize the court files. Civil summons. Now, this is the document I mentioned earlier that starts the lawsuit. This is where the court will put on a court file number, and that's how you will identify your case when you go to court for the divorce hearing. If you have to file additional court documents, we call them pleadings. So if you have to file any of those, this civil summons will be the first paper that shows what your court file number is. And then again, some counties will, if you go in person, if you don't use the e-courts e-file and serve, some counties require yellow paper. When I first started doing this many moons ago, they required extra copies on yellow paper. So we would buy one stack of yellow paper from Office Depot, but again, some may not require it anymore. So check your county specific local rules. Again, your service members Civil Relief Act affidavit. You want to have 3 of these. It's called a declaration now, so you don't have to get this one notarized, but this is where you are asserting to the best knowledge and belief that you have that your separated spouse, the defendant, whether they are active service members, inactive service members, like retired, or they were never in the armed forces. And so this is where you put that information, and also there's a registry online that you can check, and that's where you would need their full legal name, date of birth, and then social security number if you have it. And then again, optional, your petition to proceed as an indigent. So you want to have at least 2 copies of that. So I say 3 copies of everything that you have to serve to the defendant. Okay. So filing. So what happens now? We have our forms, we have our documents. What do we do now? So that's the big question at this point. What happens when we file or we're ready to file? Like I said before on the last slide, don't sign anything early. You want to make sure everything is correct as it's written. If you've done the interview on e-guide and file, then you want to go back and fix anything that's not correct when you look at everything to make sure it's ready for you to take to the notary. If you have downloaded the forms, then you want to double check if something's not correct, white it out, or reprint the blank form and fill that page out again. Again, remember the copies that I had on the prior slide. You want to make sure you have the number of copies that you need, and that the ones that need to be signed in front of a notary are signed in front of a notary. That's really important, and they could just dismiss your action if there's no notary, if there's no verification of your signature by a notary. Okay, you have all your documents, you've signed in front of the notary. Now you're ready to go to the clerk of court within your county where you're filing. Okay, what do you do now? You want to go with your paperwork and the court filing fee for absolute divorce. Now, that's what the statutes, the law calls it, absolute divorce. Remember, same as simple divorce or no fault divorce. And the court filing fee for absolute divorce is $225. And then if you're resuming a maiden name or a prior married name, it's an additional $10. So you want to make sure you have that. They don't take personal checks, so you can take cash, money order, or a bank check, certified check from a bank. Once you have all these documents ready, you give them to the clerk. You want to go, if your courthouse has a family court, you want to go to the family court office. If they don't, you want to go to the civil division. They will stamp the paperwork. They will make sure everything's good. Then they'll stamp the paperwork. They'll fill out all the forms on the civil summons to start the lawsuit. And then they'll give you that court file number, the civil court number, CVD, and then give the extra file stamped copies back to you. So this process, I would also say, make sure when you go to the courthouse, you want to give yourself enough time that if you have to leave your phone in the car, your Apple Watch, you have to go through security, and then you have to go to the clerk's office and you might have to wait in line. So I would always say, if you're going for the filing, make sure you've budgeted about 30 minutes to an hour of your time. If you're going during a busier time, it might take a little longer. If you're going, mid-morning when it's not so hectic, it might take less. But somewhere around 30 minutes to an hour will be enough time for you to go through, park, walk to the courthouse, go through security, go wait in line if there's a line, get all your paperwork filed, and then we'll talk about the next steps after you file the documents, okay? Just take a little sip of water. Okay, serving the defendant. Now, remember, we have this lawsuit filed now, so now what? Now the other party, your separated spouse, is the defendant, and they have to receive a copy of the paperwork. We call this, and I said it earlier, service of process. Those are the magic legal words. And what that truly means is they have received the paperwork, the complaint and civil summons. They have received those papers, and you have proof that they've received them. And so you're probably asking, how do I get proof? How do I get proof that they have these papers? Can't I just give them to them? I mean, we've been separated this long and we're on good terms. Can't I just hand it to them? Technically, no. So let's talk about the different ways we can serve the defendant. Okay. First is sheriff. Now, this is your local county sheriff. You pay a service fee is what we call it. And they will go and deliver it to the defendant at the address you put on the summons. So again, very important to know their current address. Another option, through USPS, you could do certified mail return receipt requested. And I actually have one of these on my desk to show you all today what that looks like, but it's that green and white card, and then paper, and then there's a larger postcard looking light green card that you stick on the envelope. And so that's what you use for certified mail. And the proof, you might be asking, how are you going to get proof that they've received it? Well, that's because they have to sign that green card. They have to sign and date it. So that comes back to you in the mail. So that's one option. I also put FedEx and UPS. What our laws say, they say a mail delivery service. So UPS, FedEx, if you think they might be more difficult to get the papers, get them to sign something, you might want to put it in a FedEx envelope or UPS envelope. But again, keep in mind that's going to be, certified mail through USPS might be around $10. FedEx, UPS might start at $40 or $50. So it gets more expensive if you use one of those options. Now, publication, what that means, I always call it a last resort option, and this is putting a notice in the newspaper. That can get a little complicated, so I would definitely say let's talk about the first two, and then if those two are unsuccessful, then we'll talk about your kind of last resort option with publication. Okay, so let's talk about the sheriff. Well, before we talk about the sheriff, the defendant, I mentioned this earlier, they have to have one file stamped complaint and one of the civil summons to be properly served. And that proof of that service of process has to be in the court file that the defendant actually received those two papers. I say papers, those two documents. We're going to talk about where does that proof come from? How does the court file get the proof? What do I have to do to put the proof there? And so let's talk about that. So now we're going to talk about sheriff, okay? First, this can be done at most clerk's offices. Some courthouses have the sheriff's department in a different section of the courthouse. So you want to go to the sheriff's department and ask for the civil process department, or say I have to have service of civil process. They'll know exactly what you mean when you say civil process, and they'll get you to the right window, the right person, or the right office if you're in the wrong place. What you want to do is you want to give them one filed copy of the complaint and 2 copies of the civil summons. And I'll talk about why you want 2 of those. Okay. The service fee, I mentioned this earlier, for sheriff is $30 unless that filing fee is waived. So let's say you filed that petition to sue as an indigent and they granted your petition, so all filing fees are waived. If that happened, you want to take that proof, that granted petition, with you to the sheriff so they know that your fees are waived and they will not charge you the $30. So just be mindful of that piece if you are choosing that option with all of the forms that you fill out. Okay. The sheriff's deputy who will take the papers, who will take it to the defendant, they will note on the back side of one of the one of the summons documents, because you give them two. One goes to the defendant, you give them one of the complaint, and the sheriff's deputy will keep one of the civil summons that you give them. They'll fill it out on the back of having the defendant sign it. They'll have the date and the address of where they served the defendant with these papers, and then they will send those papers back to the clerk of court. Now, how do you know? How do you know that proof got to the clerk? How do you know that proof got into the court file? There are a couple of ways you can figure this out. You can call the sheriff's department and ask them for the civil process department, and then you ask them or give them the court file number. They'll ask you for that number if you don't give it to them, and that way, that's how they'll check in their system to see, are the papers out with the deputy right now? Was it served? Oh, we sent the summons back to the clerk on this date. Those are different ways you can find out. Another option is, like I mentioned earlier, eCourts is live. It's live in 87 counties in North Carolina. So if you go to the eCourts, eCourts portal website, and again, you can find that at nccourts.gov. That you can put in that court file number and see, has that civil summons been returned by the sheriff? That's one way to find out as well. Again, why do you need to know the date the defendant was served? Because you will have to, the defendant gets a certain amount of time to respond to the complaint for absolute divorce. So you need to know that date, because that will help you in the overall roadmap of what step is next. Okay, so I mentioned certified mail return receipt requested. With this option, you go to the USPS, US Postal Service, any office, and remember, they're open on business hours, so not on a Sunday. Some are open on Saturdays until like noon, so just be mindful of that. You want to put one complaint, a file stamped complaint, and one civil summons in an envelope addressed to the defendant. And again, the address you put on the civil summons, that's really important, because this is giving them, one, service of the paperwork of the lawsuit, and two, it has to be at their address, right? So you take this to the post office, you fill out the green card. This is gonna be the green and white card, and you just fill it out with their name and address for the certified mail fee. And you also want to fill out the return receipt requested card. Now that looks like the postcard. It's a light green, a mint green, if you will, card, and you want to make sure you put your address on there for it to be mailed back to you. And then you put on the other side the defendant's name and address, how the envelope is addressed, because that is the card that will come back to you. If this gets a little confusing, I'll be honest, it was confusing for me the first time I had to do this for a case. So I went to the post office. I asked the post person at the teller line, and they walked me through it. So just know that people will help if you ask. Just make sure you have the defendant's name and address with you, and that's how you can get everything filled out. They'll help you fill it out and stick it on the right spots on the envelope, but go with the copy of the complaint, the summons, and an addressed envelope. And then once everything is filled out correctly, they will do the postage fee, they'll do the certified mail fee, and the return receipt fee. And that right now, you know, postage is changing, but that's about $10 right now. It might be a little more, but it's about $10. And then again, when you get the green card back with the defendant's signature and the date that they signed it, you want to keep a record of that date, because that's the date they were served. So just like the date the sheriff gave the defendant the paperwork, the date of service for this option is what date they signed it on that green return receipt postcard. Okay, so let's say you get the green card back. What do I do now? How do I make sure the court has that proof that the defendant received this paperwork? Okay, so the green card comes back. You fill out this affidavit of return of service by certified mail. This is going to be in the legal aid simple divorce packet. Again, the link is in the chat, but this document you fill out, again, at the top where it says file number, you want to make sure you fill out the number that the clerk put on all your documents. It's going to be on that civil summons. Your county, the plaintiff is your name versus defendant, their full name. And remember, that whole top section, you use the names how you put them on the complaint. So you want to use the same full legal names or first and last name, however you've listed on the complaint. Then you fill this document out that you have mailed it through certified mail, return receipt requested, and you list what documents did you serve. You served the complaint, civil summons, you can serve the Service Member Civil Relief Act declaration, and then you say you served those documents to the defendant, and then you put the address. You put the address that's on the civil summons is the same address you put on the certified mail return receipt. You put that address in here. And then you look at the green card. What was the date that the defendant got the paperwork? You put that date on this affidavit as well. And then you want to also attach the green card, the date on the postmark that the green card was mailed back to you, the postcard. And then when you get that back, I always say for good measure to make sure you don't have any questions about this affidavit of service is get a printout of the tracking history from USPS.com and staple or tape, whatever is easier, that green card on the tracking history and attach it to this affidavit of service. The tracking history is also a preference of the clerk. So some might just want to see the green card back. Some may want to see the full tracking history. So that might be a question to ask when you're filing all the documents. What do they require? But at minimum, if you do certified mail, you want to make sure that green postcard that you get back is attached to this affidavit. Now, the reason this document is called an affidavit because it is a sworn statement. That first sentence on here, it says, under the penalty of perjury, I state the following. So when we have that language, it's an affidavit and it has to be verified by an official. So this official is going to be a notary public. Again, hop over to your bank, your credit union, get an appointment with the notary, or if you need to go to the UPS store or find a notary elsewhere, make sure that you have them notarize this when you sign it. So you don't sign it until you're in front of a notary. So just keep that in mind. And then once you have this completed, you want to make sure that you have at least 2 copies, an original and 2 copies. So remember, I have 3 copies for everything else. And you want to make sure you file this with the original civil summons back to the clerk that the lawsuit has been served. Okay. Let's go. Here's another option of service. I didn't mention this in our 3-point checklist at first, but let's say you want to hand this to your separated spouse and you guys are on good terms. It's been a year. You just want someone has to start the process to get it done. Well, here's the form that we can use. So this is what you can have the defendant fill out, your separated spouse. Again, remember that top section, the heading, you want to put the court file number as well as your name with plaintiff and their name for defendant. And then the defendant will sign this in front of a notary. What this means is you can hand it to them, but they have to sign and swear before a notary that they are who they say they are and they're freely accepting these papers. Again, the date they sign this is going to be your date of service. And then this is the proof you put in the court file so that the clerk, the judge, whoever is looking at your divorce file will see, okay, this defendant, they got proof of this lawsuit and this is the date they got that proof. Okay, this is that last resort option. I don't really like it a lot, but again, a lot of times with this, people say, what if I can't find my separated spouse? What if I can't find the defendant? After we moved out, I never heard from them. Well, you have to try the other options first. Are the statutes, the laws say you have to make reasonable efforts to serve different method by different methods before you get to publication. So we really, when we say this is a last resort, it really is a last resort. Um, this is where you have to use those reasonable means first. And so when you go through this option, you have had to go through a lot of these ways to find where the defendant resides. What is their last known address that you know where they lived? You can do an internet search. You can contact friends or like family of your separated spouse. Maybe, a great resource is checking on Facebook if you had any mutual friends, or if you still are connected with any of their family members, see if you can send them like a message over Messenger. You can go to the DMV's website to see if you can find anything on there. One option I see and I have used is our private investigators. They're really good at locating people, but keep in mind it can get expensive. So you want to make sure you use reasonable means to locate them at their last known residence. And then also check with your local clerk to see if they have any other requirements about publication before before you use that publication option. Some have a general rule of thumb that you have to try at least 2 of the service methods before you go to publication. And that's how they can interpret what reasonable efforts mean. So just check with them, and then if they are telling you what you should or should not do, or what that you can or cannot do, just remember, they're not lawyers. They can't give legal advice. So even if you ask them, they're not going to tell you this is what you can or can't do, this is what you should or shouldn't do, because they're not lawyers. Some may be, but again, they can't give legal advice. So if you have questions about publication, you might want to talk to an attorney, and there are plenty of resources that we'll address at the end of the slideshow as well. Okay. Let's say you've got the defendant served. Now what? What do I do now? They've been served. I put that proof in the court file. What's next? Okay, there are different ways to get a judgment of divorce entered. We're going to talk about those here. First is a judgment of absolute divorce before the clerk. A second one is an uncontested testimonial divorce before a judge. And I want to make a distinction between 1 and 2. 1 is where you submit the paperwork to the clerk of court. Number 2 is where you have a hearing. You go in front of a judge at a designated court time and a courtroom, and you sit and wait until they call your name, your file number, to have this hearing in front of a judge. Okay. Again, these procedures vary from county to county. Some don't even allow option number 1. Some only do option 2. Some will have both options, and they have different procedures for each option 1 and 2. Another distinction to remember are there might be different rules, different special forms for absolute divorce that they require, or different customs that are applicable in that county. So again, I said at the beginning, check the local rules and forms page on your county's website on nccourts.gov. Okay. Testimonial divorce hearing. Now, this is where, if you are unsure where the defendant is, you did all that you had, you believe that they signed for the paperwork, or you had to put it in the newspaper for publication, then more likely than not, this option, this is number 2 from earlier, the earlier slide, this is going to be the option that you're going to have to work through. Okay. First, you have to wait at least 30 days from the date the defendant was served before you can have a hearing on absolute divorce. Now, this is why with every method of service, I emphasized you need to keep track of the date they got the proof of the lawsuit, the date they got the complaint and summons in their hand, or the date they signed for it if they accepted service, or the date they signed the green card for certified mail. That is the date we start counting 30 days. Okay, so the 31st day is the first day you can either submit the clerk's paperwork for a divorce or have a hearing scheduled for absolute divorce in front of a judge. Okay, on day 31 or after, you want to contact the clerk's office to determine what date your divorce hearing can be set. Now, this is something that while you're at the courthouse to file the paperwork, you can ask them, what is the procedure to have a testimonial divorce hearing? It's important to ask that question, and it might be helpful to do it before you get to 31 days. So at 31 days, you're ready to go with what paperwork you need. But generally, the documents you'll need, a calendar request, a notice of hearing. There's a $20 court filing fee for any notice of hearing unless they waive it. And then a certificate of service for the notice of hearing. Now, this will give the defendant proof. Notice of the hearing date. So after you have served them with the initial paperwork, that summons and complaint, any other document after that, any subsequent court filing, you serve them through regular USPS mail. It can be email. It could be through the eCourts e-file and serve. You don't have to pay for a sheriff's service after they do it the first time. So when you are getting ready to file a notice of hearing for a divorce hearing, you have to provide the proof that you mailed it, which is the certificate of service, and you have to actually give them a copy of the notice of hearing. Again, you really want to check with your local clerk to figure out what is the process that they have here. Is it only held on WebEx? Now, since COVID and they found that it's easier on WebEx, you need to know, and how do you get the link for the WebEx to make sure you are in the virtual courtroom for your divorce hearing? If they only do it on Mondays at 2 p.m., you need to know that. And so you can also look on the local rules and forms page on your county's website on nccourts.gov. And so the big important piece of your divorce judgment is you'll need 4 copies of that document that you're having prepared and you take with you for a hearing before a judge. And we'll talk about why you need 4 copies. 3 to 4 copies is a general rule of thumb, and we'll go through the different reasons why. First reason, you have to mail a copy of each document to the defendant. Again, like I mentioned, through US mail, email, file and serve. When you have the hard paper document in court, it's just really easy while you're at the courthouse, pop over to the post office and drop it in the mail. So I find that might be the easiest option, but whatever works for you. But the defendant must get a copy of that judgment of divorce. Okay, notice of hearing. I briefly mentioned that earlier. The document, a notice of hearing, that has a $20 filing fee, and then this provides the defendant before any court proceeding, a hearing before a judge, that they have enough advance notice to be there. Some ways that the defendant gets this notice is that certain counties, different counties have filing deadlines for absolute divorce hearings. That means maybe 3 weeks, 2 weeks before a hearing date is the deadline to file a notice of hearing. So that also makes sure that gives that protection to the defendant, that they will get enough time to appear for the divorce hearing, whether they want to and be there, or if you're doing it because it's required and that's that, and they just don't respond or appear. But just be mindful, sometimes they're filing deadlines, sometimes they're not, and you can just ask the clerk what's the deadline to file for a divorce hearing. At minimum, you have to give at least 5 business days notice prior to the hearing date. Now, when we count 5 days, I say business days because we're not counting weekends and we're not counting court holidays. So a good example of this is if you want to have a hearing the Monday after Thanksgiving, well, you're going to have to count more than 5 days because you're going to have Thanksgiving Day. The Friday after Thanksgiving is usually a court holiday, and then you have a weekend of Saturday and Sunday. So that's one time where your weekends, court holidays, will make that 5 days enlarged. And then if you're serving it by USPS, we call it the mailbox rule. We add 3 extra days. So that's the extra safeguard, what I like to call insurance, that they've actually gotten it through the USPS. So you can put in the mail on a Monday, but five business days from a Monday is not going to be the next Monday if you put it in the mail. It'll be the following Wednesday. And then if you have questions about it, I always say add an extra day. It's always better to have extra days than not enough, and you're taking time off work. You've gone through the stress and preparation to be at the courthouse to find out that you haven't counted enough days. So just be mindful about that. If you have a few extra days to count and cushion, go ahead if you have questions about, did I count enough? Okay, so I mentioned for a testimonial divorce hearing, you'll have to go to the courthouse. So what do you need when you are going to the courthouse and you want to have all the documents ready to go for the hearing and then to process those documents afterwards? You want to have your judgment of absolute divorce. You want to have the certificate of absolute divorce or annulment, and that can be found at that NC Courts forms page we talked about at the very beginning of the presentation. That form number is AOC CV 711. And don't worry about the word annulment on there. That's just the name of the form. So you want to have that document ready. I mentioned a certificate of service. That's how you put proof in the court file that you gave the defendant a copy of this divorce. And then here I'm saying, let's put it in the mail. You want to have a stamped envelope with the defendant's address on it ready to go. You'll need 4 copies of the judgment of absolute divorce and at least 1 copy of the certificate of absolute divorce or annulment. You want to fill these forms out on a computer or use black ink very neatly. And then you want to make sure you have those copies with you ready to go. There are sample forms in the simple divorce packet, and then you can also download the AOC form from the website. But these are only sample forms that you can look at and have ready when you go to court. Okay, so we've talked about what you need to have ready before you go to the courthouse. What about when you go to the courthouse? What do you do there? So let's break that down a little bit. You want to have at least those 4 copies, and you want to have of the judgment and the certificate of certificate of absolute divorce or annulment. They're going to be in your guide and file package, or you can look at the sample forms that is in the simple divorce packet from Legal Aid. You want to dress business casual. I'll say you want to put your best foot forward when you go to the courthouse, and most judges don't allow untucked shirts. Some don't like t-shirts. Most all don't like hats unless they're religious head coverings in their courtrooms. And if you do, they will send you out until you are dressed appropriately for their courtroom. But just dress like you would go to a job interview, how you would dress for church on Sunday. You want to put your best foot forward when you go to the courthouse. Again, I briefly mentioned this earlier, but most courthouses nowadays don't allow cell phones or smartwatches. So I would say leave them at home or in the car, or some courthouses have secure lockers where you can put a quarter in to store your electronics before you go into the courthouse. So you'll have gone to the courthouse before to file the paperwork. So you'll have known whether they have the lockers or you have to leave your phone in the car or at home. So just be mindful of that. that you can't take those electronics if that's the rule for that courthouse. Arrive 15 minutes early. I think, oh, sorry, I went words. You want to arrive at least 15 minutes early. I say plan a little more time if you're unsure about parking and additional time to go through security lines at the courthouse, especially if you're going right for a 9 a.m. court time or a 2 p.m. court time after the lunch break. The security lines are really big. They can kind of get backed up. So just plan a little extra time if you also have to park at a parking deck and walk over, or if you need to look for parking. It can always be stressful. And I say, if you're going to go and do this, just take the extra time to cut out as much stress that you have within your own control. You want to sit in the gallery once you get to the courtroom. The gallery are like the chairs behind where the attorney table and the judge and the witness are. So you want to sit in the gallery and you want to just make sure you pay attention and you hear for your name to be called and your case number. Sometimes they'll just call the parties' names. It'll say blue, they'll say blue blood versus blue blood. And then once you hear your name, you stand up, you say you're present, and then they'll tell you what to do next, whether to wait there until they call you again, or they'll ask you to come to the table and go through the process. So just be really alert. If you think you might get bored, take a book. But again, remember the whole electronics thing. Okay. When your case is called, you want to approach the whether in this they'll tell you, and if you don't know where to go, ask. They'll ask you to either to approach the bench with your paperwork or the tables, the actual party tables, or they'll tell you to go to the witness stand. And at that time you will be sworn or affirmed. The difference is you swear on the Bible or you affirm that you're going to tell the truth when you give all the information the judge asks. When you're testifying, you want to speak slowly and clearly. I often tell clients, I say, if you get stressed out or you talk fast, when you get nervous, take a deep breath, get some oxygen running to your brain, and then answer the questions. And also, this is a really great example. Use your judgment of divorce to guide your testimony. If the judge doesn't ask any questions, use your draft judgment of divorce to say, I'm the plaintiff, my name is blank, and I have lived in North Carolina for the past 6 months before I filed this lawsuit. The defendant is blank person and they live in North Carolina, or they live wherever. We were married on this date in this location. We were separated on this date. These are the children that were born during our marriage. At no time resumed the marital relationship. You go through that, and that will help you guide yourself how and what to say. Because I can tell it gets stressful. You get nervous. You jumble your words, and you might forget something that you need to tell the judge. Here's an example, just like a screen grab of an example of a sample judgment for absolute divorce. You'll see from the simple divorce packet, it's a fill in the blank like some of the other documents that we talk through. These are the blue bloods from Orange County and Durham County. Again, it's in your guide and file packet for sure, and you want to take 4 copies of this document. And make sure at the top, remember, you want to fill out the parties' names at the very top, which county you filed in, and where it says file NO dot blank CVD blank, you want to fill in the court file number, because that's like the identification number of your lawsuit. That's how any court personnel will identify your case. So even if you accidentally invert the number, it can throw some things off. So always double, triple check that number when you fill out any of these court documents, especially the judgment of absolute divorce. If the judge grants your divorce, he or she may ask you for this document so they can sign it in the courthouse while they're there, and they'll give it to the clerk to make sure it's entered. And so I mentioned this earlier, for all the documents to have ready when you go to the courthouse for your divorce hearing. You want to make sure that you mail a copy of this filed judgment of absolute divorce on the date you put on your certificate of service, and then you actually put it in the mail on the day you put on the certificate of service. Here's that certificate of absolute divorce or annulment. This is going to be in your guide and file forms. And when you fill out the interview section on guide and file, it'll populate all the information in the right spots. But if you have to download this form from the NC Courts form page, this is what it looks like. You want to type it or use very neat black ink when you handwrite it. I have messy handwriting, so I usually will type it. So it'll be a fillable PDF. And so remember, at the top, you want to put your court file number and the county. And then the part where it has marriage, you want to put your date of marriage, where you got married. Now, I would say county and state is the most important part. Any minor children at of the marriage, and then the date of separation. Okay, after the hearing, what do you do now? You went to court, you waited, they called your name, you gave your testimony. What do I do now? Okay, the judge will determine if they should grant it or if they should ask more questions or if they need to look over all of the court documents again. They'll take some time, so don't stress out if they're not saying anything after you've said all your testimony. They might be looking at all the court documents to make sure everything is in the court file. And this is really when they look at that proof of service of the summons and the complaint. So it's really important that you have it all in order, because they might continue the case if they don't see something in the court file that should be there. Let's say they grant this judgment of divorce. All your hard work, you've gotten what you needed from this lawsuit, you have to send it to the defendant. So you want to complete the certificate of service for the judgment of absolute divorce and mail a filed copy to the defendant of each document, the certificate of service and the judgment. After you do that, after the hearing, mail it. And that's why it's important to bring that self-addressed stamped envelope I mentioned when you're preparing for court, because it just makes life really easy to run by, pop over to the post office after court and drop it in the mail. You want to keep a copy of the judgment of judgment for absolute divorce in a safe space in your house or safety deposit box, somewhere where you keep your other important papers like a birth certificate or your will or something like that. You want to make sure that document is in a safe space. Okay, so back when we were talking about filing, I mentioned if you resume a maiden name or prior married name. If you had a name change in your judgment of divorce, you want to get at least 2 certified copies of the judgment of divorce. I always say you always want to get at least 1, even if you don't get a name change. But if you get a name change, I say get at least 2, because you will need to change your name in the first 2 places you go, the Social Security Administration office and the DMV. Those are the first 2 places I always say to go there, and then everything else will fall in line, like banks and credit card or employment or doctor, to update your new legal name. But always get a certified copy, because those are the 2 offices that will request a certified copy, and some places like a bank or credit union might request it. And it makes life a lot easier to make sure you have everything while you're at the courthouse. And then one other thing about certified copies, I didn't put it on the PowerPoint, but it is a $3 court fee for a certified copy. So just keep that in mind if you want to get a certified copy while you're at the courthouse. Okay. I've talked a lot, and I believe there's some questions that came through, but if you have questions, you need more help than what I've talked about, the PowerPoint, you can call Legal Aid. This is their number, their website, legalaid.org. They have a lot of information on their website, and if you can't get an answer from them, I would say the North Carolina Lawyer Referral Service. They can do discounted consultations with attorneys for 30 minutes for $50. So if you just want to go there and find an attorney who can help you make sure all your documents are right, that might be an option. But with that, I think that's all I have, Marissa. If you want to help me with the questions, if there are any.
Perfect. We do have a few questions. Again, if you have a question you cannot unmute in this forum, you either need to type it in the Q&A box on Zoom or in the comments section on Facebook. And I just put a link to the North Carolina Law Referral Service that
Thank you.
Manisha mentioned. First question, I think this person is asking, say the relationship between the two spouses. I'm assuming this was more of a domestic violence situation. So the spouse looking to get divorced does not want to have any contact with their other spouse. Like, do you have any ideas about what to happen when maybe you don't want to you want a divorce, but you don't actually want to contact your other spouse for safety or other reasons?
So I'm just going to answer the first part, and then I'm going to give a different answer for a different scenario. So the first part, if you don't want to have contact, unfortunately, they have to receive notice of the lawsuit, or else the court, I can't give definite like yes or no's from what a judge will or will not do, but if they don't see proof of service in the court file, they won't move forward with anything. So you will have to have contact. Now, if there is a safety concern, and let's say there's a domestic violence protective order, a 50B, I would say at that point, it might be worth paying an attorney to do this so that their address is on everything and none of your contact information is listed anywhere other than on the initial paperwork, and have the attorney make that contact. That might be a good way to not have direct contact.
That was a wonderful answer. Um, let's see. Someone's asking, they don't think that a simple divorce is going to be right for them because they need to divide property.
Mhm.
However, in terms of contacting a lawyer to maybe get the process started or even get the separation agreement, should they do that before or after moving out? Do you have to move out before you have a separation agreement?
Okay, so there is actually case law from, I believe, 1996. Don't quote me on that. I believe it's 1996 outside of, it started in Forsyth County, and it says that basically you can sign a separation agreement prior to a legal separation. Remember what I mentioned, a legal separation date. This case says you can do that, but you have to include that your projected date of separation is a certain date within the next 30 days, a reasonable time after executing the separation agreement. So that's something to keep in mind, that if you are working with an attorney and you want to have all your T's crossed, I's dotted, all of that, you want to probably do that before, but have a move out date ready to go that the attorney can list or say within the 30 days from execution of this agreement. But beyond that, I would say if you don't have a move out date before and you want to get a separation agreement done, you probably need to wait until after you're legally separated.
Perfect. Next question. Can a divorce judgment be entered without the defendant coming to the hearing?
Absolutely. A judgment of divorce can be entered with just the plaintiff present. The main thing is that discussion we had about the notice of hearing. You have to give them at least 5 business days notice of whatever date you're having the testimonial hearing in front of a judge. And as long as that has been met and that proof is in the court file, that not only you filed a notice of hearing, but also you gave the defendant notice of that court date. Like, you serve them with a copy of that notice of hearing, and it's at least 5 business days, you're good to go. If they show up, they show up. If they don't, that's their prerogative to not show up. But that's the most important piece. And so really, if you've met the legal requirements of an absolute divorce, there's not much they can do to stop it. It just depends on how the judge will receive anything the defendant may say in court during the hearing. But they don't have to be there if they don't want to.
Perfect. And then the last question I'm seeing at the moment is, oh wait, another one just came in. What are your ideas for service when it comes to someone who is out of the country?
Okay, so this one's a loaded answer, and I'm going to answer that with it depends. So it depends on which country they're in. If that country is a party of the Hague Convention, it might be a little easier to serve them. But if they are out of the country, there are a few options I would suggest. And so one of those is if you are communicating with them and they're you know where they are out of the country. Let's say they are in, I'm going to use an example I've encountered. They're in Germany, they're in Berlin. Well, see if they will accept service. And by accepting service, we talked about that acceptance of service form, but they would have to have it signed at an embassy or a consular office. And so, do they have access to that if they live in Berlin? I had to serve somebody in a rural part of Italy before, and they didn't have that option, and they didn't have anybody anywhere close by, so the defendant made a trip to, I think it was Milan, to a consular office to have that paper notarized. Another example, now this one will get expensive. I just had to serve somebody in the Philippines. And so we use DHL. That's an international express delivery service, and it can get expensive. So that one, I would say it costs somewhere about $140, I think, about there. So it's really important to see if they're out of country, see if they will agree and accept service. If not, I have found DHL as the best option and most secure.
And then another question about service. Um, oh, I'm sorry. I just lost my whole train of thought. What if no one knows where the other spouse is? Like, there's no other way to find them for maybe the first two options of service.
Okay. You still have to go through the steps of serving them at their last known residence that you're aware of. So if you worked with a private investigator, a PI, and they found their last residence was 123 Main Street of Greensboro, North Carolina, and that's what the PI said, you would attempt service at that location. And at that point, when you have to go to publication, you would find the legal newspaper or newspaper in that county where legal notices are posted, are published. And again, I say newspapers nowadays, you don't see a lot of people getting newspapers, but reading them online. I read the newspaper online. So it'll be a legal notices section on their virtual digital newspaper and on the paper, like hard copy newspaper. And it has to be published for 3 consecutive Wednesdays. And the defendant gets 45 days to respond, not 30. 45 from the first Wednesday of publishing. And so once that has been completed, the newspaper will mail back after of course, they've gotten their publication fee. They will send you an affidavit, a publisher's affidavit. And then, like we talked about, the affidavit of certified mail or service by certified mail, you would have to do an affidavit of service by publication. And you have to explain all the different options that you use, the reasonable measures before you did publication. You also include a copy of the publisher's affidavit, and you sign it in front of a notary, and you put that in the court file. So it gets complicated if you really can't find them, but you have to try at their last known address. And so if you look at DMV records, if you have a PI that has tried to find them, if you've tried the last known address you had, which was, 3 months ago, and you don't know where they are, none of their friends on Facebook know where they are either. You have to put all of that in your affidavit of service by publication. You can also add, I reached out to defendant's mother on Facebook. Attached is the screenshot that they don't know where they are.
Perfect. And then someone's asking, The spouse has moved to another state. However, they will return to North Carolina for appointments and other things. And when they return, they do stay in the marital home. Does that restart the clock regarding the separation date? And I can repeat.
Yeah, I'm thinking about in that one, and again, I'm going to give the lawyer answer of it depends. But with that, I think the what depends is what how a judge will interpret that. Are they going to stay there for two overnights and pay you $200 a night for it like a hotel? Are they staying there because the kids live there and they're part owner of that house or formerly lived there? Are they living there, staying there for those two overnights, and y'all are having a family dinner and spending time together watching TV shows? Or is it an Airbnb that you rent out and they're going to stay in that instead of you renting it out for those two overnights? I think there's a lot of different circumstances about that. As a lawyer, I would probably say don't let them do that because it gets too murky. It gets too cloudy with trying to determine that resuming the marital relationship. Like, are you like holding yourselves out as a married couple at that point? Or is this literally a convenience? Is it so they don't have to pay for a hotel or an Airbnb? What is that purpose? So I think it gets a little cloudy there of giving you a direct answer. But those, I hope those questions can help, clear, different options that you may or they may have.
I think it does, if that means anything. Um, and then I don't think this is mentioning the publication way of service. So talking
Okay.
about the other two ways of service, how does that work when the spouse is in another state?
Thank you for asking that question because I was thinking, did I mention serving out of state? So service of civil summons and the complaint, and let's say we're here in North Carolina. I'm going to give an example of Virginia. Let's say someone you separated, no kids, they moved to Virginia, and you know where their address is, but you don't want to communicate with them. I would say at that point, contact the local sheriff's department. Let's say they live in Richmond, Virginia. I can tell you what county that is, but let's say if it's Richmond County, or Chesterfield County, Virginia, you contact that sheriff's department and ask them, what is your civil service process? Like, what is your fee? I believe Virginia charges $75 out of state service of process. I had to do it, I think, a couple years ago, but different states will have different sheriff fees and they'll do the same thing. And instead of sending it back to the clerk at the courthouse, you ask them to mail it back to you. Always include a self-addressed stamped envelope for them to mail that proof of service from the sheriff out of state back to you, and then you file that at the courthouse as the proof that the defendant got the paperwork. If you don't want to do sheriff service and you know their address and they're expecting it, you can get serve them by certified mail return receipt requested. And once you get the green card back, go through that process. But if they're out of state, it doesn't change the different options. It just changes sometimes the cost.
Perfect. Well, I am not seeing any other questions, so gonna check one last. Nope. So I'm gonna go ahead and say thank you to all of you for
Thank
joining
you.
us with a very special thank you to Manisha for presenting for us and for answering all of those questions. If you'd like to review anything that we talked about today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access the recording also on Legal Aid North Carolina's YouTube at any time, starting next week by selecting the Listen and Learn playlist. If you would like to register for one of our other Listen and Learn programs, such as child custody, fair housing, tenant rights, you can do so on our website at www.legalaidnc um, .org/clinics. Thank you all so much, and I hope everyone has a wonderful rest of their afternoon.